Welcome to the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. We go over domain name legal news. We review recent UDRP decisions. There's three hosts of this show. My name is Todd Ryan. My co-hosts are Jeffrey Neuman and David Michaels. I'd like to say hi to my co-host before we get rolling. Hi, Jeff. How's everything going today?
But then I got to go vote. It's important to vote.
Yeah, fantastic. And I always go to the person that's here first. So you were here before David, which is normally the case. So if David wonders why too, that's why. Sometimes I'm dancing. You guys don't know. I'm listening to Boss Gags. I'm really getting down. I don't let people know it. It's not on video, but I'm looking at my computer thinking, is David? Where's he at? Jeff shows up, it's like, right a minute before. David acts like, I know there's something I'm going to do today. What is it? Hey, David, what's going on? How's everything with you?
Today's all right. Not much.
This guy, it's like it reminds me of if I was producing like a reality show, I'd think, we need something. Come on, we need more from you. How's it going?
Oh,
Good.
no, the
Yeah.
best thing, what it reminds me of is in the movie Major League, when Bob Uecker turns it over to the supposed color guy, and he makes like a one-word answer, and Bob says, "Well, he doesn't say much, but what he says, wow."
Well, David, he wants to get to the cases, and he's got plenty to say. I know about the cases, especially Word Day today. But until then, sometimes David, when we used to have like some people come on stage and they're talking before we get to our cases, I just imagine him sitting there looking at his watch, thinking, "Are we going to get to these cases? Todd, fucking move it along. I mean, can you move it along? I mean, can you if you're going to, lead the stupid thing, lead the stupid thing." That's how I picture David sometimes. But then I realize, I mean, he's probably messing with the webs. Well, David, let me ask you this about the other website that are you still putting blogs up on domain law? Is it podcast.com? What was the website?
Yeah, domainlawpodcast.com. I haven't posted late recently, but I've got some things queued up, so it's just a matter of me getting to that and posting them all.
Yeah, it's good to have the content. Well, anybody knows we stream here on YouTube as well. The YouTube is youtube.com/trabc. But why do that? You can listen to a replay here. You can listen to it live here. I don't know. A few people plug in there, I guess. But if you want to follow along with what we're going to cover today, you can go to dnlshow.com/outline and you can see our outline. Today we were going to touch on, I think, interesting topics today because there's been comments on these news articles. And the first one was on DNW, but I heard about it through some other lawyers that were talking about this complainant used forged trademark documents in a case, and it was the case was Chafe Zero, I believe. Let me double check. Yeah, CHAFE 0.com. But the bottom line was this complainant filed this case, and they apparently applied for a trademark, but it wasn't registered yet. But they submitted it looked like a registered trademark. I think even with a stamp symbol or some other documents too, and brings up a lot of questions about how far a complainant can go in submitting not only fake documents, but Zach brought up in a post on the ICA blog. This yet that just got released today, and their digest each week about, why can't just a fake complainant say, hey, here's here's not only maybe a legitimate registration, and say, I'm this person that owns this registration, because anyone can file. And we're just basically coming up with ways people can sort of mess with the system, not be the complainant or not have a valid trademark, but yet still file. There's nothing preventing them from filing. Well, Jeff, what do you think about this? About people filing fake trademarks? In this case, at least the panelist did a little bit of research, but I wonder if there's been fake trademarks in the past that have just made it through. You think possible?
I guess anything's possible. I would hope not. But I think the thing that gave it away, first of all, was the fact that the number um, was too long to be a registration number and was clearly then an application number. And so I guess that's what raised a little bit of suspicion. And so, yeah, I think that was the first thing that gave it away. Interestingly enough, I looked at the trademark application today. So there was really a trademark application that was filed, but because they lost to this case, the party that filed it just expressly abandoned their trademark application. So, it shows that they were just trying to get this application in so they could steal the domain name. And once, they realized that wasn't going to happen, they withdrew, they expressly abandoned their application. It hadn't even been assigned to an examiner yet. It was so new. It was like 2 months old or something.
What's even more odd is before this decision came through, they applied for a second mark for chafe, the exact same word, and then same goods except that it was more succinct. They actually used a pre-approved term for lip balm, and the exact same applicants, and they paid another $350. It makes no sense. But Alina Chung is like crazy. Either that she can be indicted for what she did, because claiming to have a trademark registration when you don't is fraud, and it's also a violation of the Lanham Act. Why was the complainant AK Associates? Makes no sense, because that's not the applicant in the trademarks. It's an LLC, so you put the actual LLC name. That's the entity, not the individuals. So many errors there, but yeah, she can go to jail. It could be like 5 to 10 years. This is not a first offense. But what was really striking was in the decision, there were quotes from her email that she was saying that she got from the USPTO, saying that she could go ahead and start using the name in Australia, which makes zero sense.
Wow, the USPTO, they have that extraterritorial reach.
So, but it gets better because it was signed by somebody. Let me tell you exactly who it was. It was signed by oh, maybe they put it someplace else. I don't have the quote right now, but it was just the wrong kind of person that would respond. And they don't send out these kind of emails. But what I think actually she's doing is she's mimicking the type of scam emails that everybody who applies for trademark gets from scammers. And they make the same mistakes. Oh yeah, it's from the primary patent examiner assistant with the USPTO. That is a red flag. There is no primary patent examiner assistant dealing with trademarks ever.
Yeah, and so when you've got panelists who are mostly trademark attorneys, they're gonna obviously recognize that right away. I'm not sure though if you had, let's say, I'm trying to remember who the panelist was in this case, but
Steve Mayer. I always remember because Steve Mayer and Phil Mayer were ski guys in the Olympics years ago, and I always think, is that the same guy that become a lawyer? But Steve Mayer, Maier, was the.
yeah, I'm obviously familiar with U.S. trademark law, but it's curious whether like what would happen if they were given like a European panelist that wasn't familiar with U.S. trademarks, and whether that would have just slid right through. I mean, there's a lot of indications and red flags that David and I and other U.S. attorneys and people familiar with U.S. trademark law would pick up immediately. But I'm not 100% sure that someone not from the US and maybe not as familiar would necessarily pick up on those things.
So in this case, this was ruled a complaint denied. Of course, Steve Mayer said, "Yeah, there's no real trademark here. I'm glad I did some research. Um, Complaint denied. Obviously, you're abusing the system." But Jeff, I know there was a case, and we have a friend of the show that's going to be joining us today, Igor Motsny. He represented the domain owner in our first case that we're going to review today, AUSFAIL.com. But Igor was part of a case. I'm trying to think of the Le Melier, or I'm not sure. I can't remember which case, but somebody the complainant submitted some fraudulent paperwork there too, I believe. But I'll ask Igor when he joins us on stage. But when someone sends in, this basically submits as evidence a USPTO mark, or I guess they could, it could be a, registered mark anywhere, say from Switzerland or from the EU or whatever. Do the panelists, I mean, would you say it's a coin flip half the time? They go ahead and check that registry or whatever you call it, or do they just take it, take the word of the complainant if the paperwork looks legitimate?
I mean, I always when I get a case, and I just actually submitted a case in today, and got another one immediately. I always look first at the certificate and see if that looks good, and then I always end up at some point when I'm doing the review just checking the online USPTO database, and now you know I mean, I do that anyway, but I might move that up to just checking the USPTO database first, if that's what's cited, rather than just checking the certificate, since we've now seen a couple cases of fraud. So, um, but not every panelist, I'm sure, does that. I think they should, but not everyone does.
Yeah, that's something that the providers should be doing, like WIPO and ADR Forum. That they should do their due diligence immediately, check things. This should be part of it.
Yeah, they kind of say, well, if the forum would say, um, and I don't know what Whiteman would say, but the forum likes to say that they don't like to get involved because they're supposed to be completely neutral and they don't want to do research on behalf of one party or another. I think that's kind of BS, right? I mean, all you're doing is, making sure that there's a trademark registration, which, is a basic requirement. That doesn't help or hurt any party, unless, of course, the complainant's lying and doesn't have a trademark, and then in which case the complainant deserves, to be called out for lying.
Yeah, the point of us having panelists be fair but informed. So I think I had a discussion about this with some attorneys saying that if WIPO and the forum used AI to just confirm some evidence, so when someone submits a trademark, they can search it in that database and so on and say, yes, it is accurate, maybe confirm dates. It made me think that what if somebody well, I guess they wouldn't do it if they actually supplied the actual registration. Because I was thinking if someone said, we have this registration and here's our registration number, and they made a mistake and put the one digit wrong in a registration number, and then an AI could say, it could actually, figure that out too, but you're not trying to help out either party. So I do think there's some room for these service providers to have AI look at the evidence and just, confirm, or, verify certain things. And there's some things we wouldn't want it to verify because, like I said, you don't want to help out either party, but you could certainly verify evidence if it's accurate or if somebody's supplying some, fake materials. Um, the second piece of news. So anyway, that was about a company that, a complainant that filed a case but supplied a fake registration, a trademark registration, and they got caught. Yeah, like David said, pretty big deal. Of course, in the UDRP they lost, but it could be bigger penalties. The second news article is from, I really thought it was interesting. We did talk about this too. WIPO alerts. I linked to the Domain Gang article on our outline, but WIPO alerts the public about fraudulent domain name disputes. And I mentioned this to some friends. They were lawyers, you guys, lawyers like you guys that deal with domain stuff. And we're talking about, well, it makes sense. I think we're going to see, maybe it's happening more frequently than we know, but basically someone receiving an email that says, hey, this is from WIPO, or the email that's in question here that we're talking about is, yeah, somebody fraudulently said, this is a WIPO email. You're about ready to receive a UDRP. You probably want to, transfer the name. I don't even know what the full-on email said. I'm going to have to look at the Domain Gang article if he actually had the email. But WIPO basically said, don't click on any links. Don't do anything. We are not going to send you, an email saying you're about to receive a UDRP. We're going to send it to you when there is an actual case. So if there's not a case number on your file, on the email, it's fraudulent. So, but I was saying that I think people, they don't even know what WIPO is, or what the forum is, or what a legitimate email looks like. So I could certainly see someone sending an email to try to steal a domain saying, hey, we are preparing to file a complaint with WIPO. We want to give you this chance before you file, or before we file, to transfer the name. Basically almost like a cease and desist, but a little more confusing, saying, you may be using WIPO and stuff. But anyway, did you guys, what did you hear about this fraudulent attempts that people are, emailing folks, and then WIPO's official announcement on their website?
I haven't seen any examples. All I see is the warning, like domain name registrants have been receiving fraudulent communications that claim to come from WIPO about non-existent domain name disputes. All current domain name cases are administered by WIPO and are listed by case number on their website. Honestly, it is actually hard to find that link if you don't know anything about this thing. So
Yeah, and the other thing I would say is that, as David was saying, as you were saying earlier, there are a ton of scams that um, of trolls that follow, or the U.S. Patent and Trademark Office application process, and so there's been those kind of scams and fraud for a long time with the USPTO, and it doesn't surprise me a bit that now there's fraud on the WIPO system too, or on UDRP. So, like David said, I haven't seen an actual example yet, but it doesn't surprise me.
So I'd like to see these emails and see if they're actually spoofing the WIPO email address, like wipo.int. That would be interesting.
Yeah, I think we're going to see. I don't see how we're going to see less as more people get involved and think, how can I get a domain name? Well, especially when, well, a lot of folks, they don't answer these UDRPs. But then if someone, it would make sense to me, hey, you're about ready to receive this complaint. You can circumvent it. You can stop it in its tracks if you agree to transfer the name. And I can see, official looking stuff. We used to do this in the collection business. You make it, seem like it's coming from some type of authority, but a third party that has any kind of authority. But I don't know. I just assume. So we were talking about two things here today that have happened. People filing a complaint, because anybody can file a UDRP complaint. And we got all sorts of things we're going to talk about with lawyers at NamesCon. If you're going to be there, got a couple panels that we're going to talk about how to, avoid a UDRP complaint. And if you get one, what to do. And then we're going to have a mock hearing to show you, here's the type of complaints that come in on a sample case. Here's what complainants, lawyers try to present to be successful in winning the case, and then how lawyers defend it. And we got Jason Schaefer, and we have John Barry Hill, and we have our own Jeff Neuman, and we have Karen Bernstein. Zach Muskovich may or may not, if he's there, he'll be part of the panel. If not, he might just write in something. But the point is, we're really going to have plenty of stuff about UDRPs there, because if you haven't received one, congratulations. But usually, if you have a portfolio of 1,000, 2,000, even less than that, but when you start domain investing seriously and you get valuable names, especially on the drops, you'll be surprised. People, if they're making offers on your names, that means you're lucky. People like them. But if you see offers coming in, that means people are interested and they're going to try things to get your name. So we've talked about a complainant that came up with a fake trademark just so they would have standing and tried to get a name. Fortunately, the panelists did some research and it was denied. But the second is people are trying to, convince domain owners that you're about ready to get a complaint or the complaint's on the way. Here's how you can, cut it off at the pass. And I can tell you, I'm sure, there's people that have fallen for this stuff. There's just no doubt about it. This third news article has not to do with the UDRP, but with GoDaddy search. And GoDaddy has I haven't seen it, and I guess why I could just look and search, but this was a domain investing article. So that's Elliot. He had this article, and I've heard some other folks talk about it, but GoDaddy Reputable search tab addresses front running. So apparently, if you're searching, whether just domain names anywhere, there's a little button that says reputable search, and they basically saying that we don't, use your search information. We don't sell it. We don't take advantage of it. Meaning if I search for a domain name, they're not going to front run me and go ahead and register that name if I'm just looking at it and I haven't registered it yet to try to get it before I get it. Or they're saying that they don't sell the data, because there is a lot of information. There's a lot of tools out there us domainers use, and somebody does have that data. Whether or not they're using it, exploiting it, well, some of them do. And GoDaddy's just now saying that we don't do that. In the past, I think 20 years ago, they got caught for doing some things like that. But not just GoDaddy. We were talking the other day in a domain room about, I search a name, then all of a sudden it's taken. In most cases, I'd say 80-90%, it's coincidental because you're watching something on TV, you think it's a cool saying, or it's on the social platforms and you think, you know what, somebody just made a big announcement. I'm going to go after this term that's popular now. So a lot of other folks do it. But sometimes you're searching things that no one else has ever searched. You're almost certain of it, very unique stuff, but then you check it a couple days later and it's registered. Now, in some cases, that first place you looked at was inaccurate. It showed that it was available. I use instantdomainsearch.com, and there are some times I'll find a name that shows available. I'll go to register it, and it's taken, and then I'll look at the who is, and I'll see this thing was registered many months or many years before. So really it was the tool that I was using that gave me some false information that it was available. But there are some times that you'll search a name, you'll think it's real unique. It wasn't because it was in the public's, conscious right then. And all of a sudden you see you didn't register it, but yet you check the next day and it was registered that night before. And you think, unusual. Well, I got to tell you, I know that a lot of these companies have the rights, whether it's a registrar or whether it's a who is tool, they have the right to use your data for themselves or to selling, platforms do all the time. They can use the data and see who's searching what. Matter of fact, somebody brought up that Mike Seiger has a tool where you can search the renewal costs. And a good example is you can, he'll show, look, people just search what the renewal cost was on this name, on this name, on this name. So previous names. And it can be helpful because you're looking for trends. What are people searching? But what we're getting at is that data is there. So if a company wanted to take that data and somebody else was interested in it, they could give it away or they could sell it. And basically, I just believe that in some cases, people are getting front run. Okay, in some cases, it might be the minority, but it's like when they say someone dies of COVID, one death's too many. So I'm just not a believer that every company in here, every company in the industry is honest and doesn't sell search data, especially when it comes to marketplace platforms that know what people are searching, for not just domain names but terms. This is valuable how companies make money by selling their data. If I had a platform, I don't know. I mean, I wouldn't want to hurt my primary customers, but if I'm offering free services to them and I have to make money, I'm probably going to consider selling some of the data that's not personal. All right. So, Jeff, and then David, do you think in all cases, I mean, is there some front running out there? Is there some data being sold that can be a detriment to domain investors?
Yes.
Go, Michael.
I
Yeah.
think I remember this happening a lot 25 years ago, before everybody had SSL certificates. And apparently there was packet sniffing going on, and it wasn't just the registrars, but people getting in between and sniffing, what your searches were on GoDaddy. And that was a problem, because I would see like minutes later the name I just searched got registered. And so people learned back then, okay, if you're going to search a name and you want it, you better register right away.
Yeah, and I believe front running is a violation of the registrar accreditation agreement. Um, yeah, I think Network Solutions way back when was known for their front running. Um, I know they get some data because if I search for something on GoDaddy and I decide, you know what, I'm not getting it, I'll get a bunch of emails saying, hey, this is still, you know, this is still available. Hurry up before it goes. So they must capture the data, but I have not seen an issue in the past few years where they've actually registered the name or where it suddenly gets put onto a secondary market where GoDaddy could get more. So I just haven't seen it.
The other thing is there is search data now being provided to domain investors. So if you have a keyword, you can see how often that keyword is searched. So I can tell you one of the highest ones searched on Namecheap is, and it's a four-letter word that starts with the letter T. And if you happen to have one of those in your portfolio, you'll know about it. So that could be the basis for registering other names, because obviously that same four-letter word is already registered in .com, and I have a different TLD, but it doesn't mean that you wouldn't get a different variation of that. So things can happen.
Yeah, when we're talking about it, if you have any experiences with this, raise your hand and we'll bring you up after we go through our cases. We're going to start reviewing our UDRP decisions, but we'll try to get through them fairly quickly. And then if you have any questions or comments for the attorneys, or you have any questions or comments about, the three news articles that we just touched on, especially about the front running. But anyway, we brought it up because GoDaddy now has a little mark on its website that says, we're safe here. You can search with us, which maybe, couldn't we always do that? I invited Igor up. Jeff, I don't know if you can try to invite him up. Maybe he's not getting my invites, but our first case is a case that Igor defended, and I would love for him to be able to participate, basically share with us, because it's an interesting case. The case is disputed domain is ausfail.com, ausfail.com. And, well, great. So Igor is on stage now. Hi, Igor. How's everything going over there in Serbia? I know it's late for you. Thanks for joining us.
Yes, hi, Todd. You hear me?
Yeah, a little light, little low, but we can
Let
hear
me
you.
try. Yes, thank you. And hi again. Hi, Todd, and hi, Jeff and David. Things are good in Serbia. We have our own domain conference today and tomorrow, APTLD, which is Asian Pacific Top Level Domains. So we have some fun here with domain names. And thank you again. Thank you for the show. And I'm always glad to join you live if I can. So I'm happy to talk about the case.
Well, great, Igor, and I look forward to hearing about that event. So, the event there, is it a couple day event, and where do they hold it at?
Well, this AP, you mean this event that's happening? You mean today and tomorrow, right?
Yeah,
That one.
yeah.
It's Asian Pacific top level domain names. So this is for CCTLDs from the Asian Pacific region, but it's also for the associated members. So obviously, we in Serbia we are not Asian Pacific region, but we are an associated member of the APTLD. So we're basically talking about all things related to this CCTLDs and to domain names in general, like DNS abuse, some updates from the registries, and we're going to talk about, how to work with the government tomorrow, for instance, how registries should work with the government and all these policy issues. So I'm looking forward to tomorrow.
Yeah, and all the regional organizations except for the North American have these regional conferences. So you have the Asia Pacific that Igor's talking about. You have Center, which is the
Yeah.
European-based organization. You have LAC Nick, right? Yeah, that's the or is it LAC TLD? One of those is the. I always get confused. That's the Latin America region. AFNIC is the African region. Uh, North American because it's really just the U.S., Canada, and that's pretty much some of the islands. Um, that's the whole North American region. So there's not. They don't really historically have not organized any North American similar conference.
I look forward to hearing more about it next time we speak, Igor. So these next couple of days, I know you're doing that. About this particular case that you were part of, you represented the domain owner, the domain AUSFAIL.com. And important that the fail was in the domain name. And I'm going to give you a little bit of info, and then I'm going to ask Igor to sort of give us some details about the case. But this case was a company, Universal Services America, is the complainant. They were going after this gentleman, Eric Deutsch. Okay, and as I mentioned, Igor represented Eric in this case. It's interesting because this complainant is a big security company out of California, and the domain owner, Eric, is also out of California. But this case has some details to it with regards to, well, most importantly, this respondent, this domain owner, had filed a lawsuit against this company a couple of years ago before registering the domain name in March of 2025. So he registered the domain just 6 months ago and then put up on the website some non-commercial free speech stuff, let's say, about he was unhappy with his experience with the company, but was also using a lot of third-party articles and really just displaying some articles that were critical of the complainant. So I wanted to start, Igor. Tell us a little bit about. Okay, you're a panelist in this case. You're representing a domain owner. Tell us a little bit about how you were contacted by the domain owner when you first received the complaint, and basically what your process going through it, and then some details of this particular complaint and how you responded to it.
Yes, thank you, Todd. And actually, we got in touch via X, via this very platform we are talking on now, and because he has his X account also for this project. So basically, we exchanged a few messages on X. Then I asked him, so could you please send me the complaint? I understand what it's all about because I saw the website, and then obviously I could have kind of predicted what the complaint would look like. But again, it's important to see the submissions first, the complaint and annexes. So when he forwarded the complaint to me and all the annexes, and there were lots of annexes, basically it's kind of classic free speech case in the UDRP, and once in a while we get cases like that. It's not very typical for the UDRP, but we have free speech and criticism cases, and this was exactly this case where my client, the respondent, he was upset about the complainant, so he filed a lawsuit first, and then he created this website because he did some research on the complainant, and apparently, even though the complainant is the largest provider of private security guards in the world, and it's actually one of the largest employers in the United States, the complainant is criticized by various sources, and there are lots of stories about complainants' failures. So my client, the respondent, basically what he did, he aggregated this information from third-party sources, and he also provided his own opinion about complainant services and what was wrong with the services and some failure stories. And then he received this UDRP complaint, which he was kind of surprised because obviously, the respondent is from LA in California and the complainant is a US organization. And then suddenly you receive some documents from the World Intellectual Property Organization in Geneva. And I guess if it's like US thing, that you probably don't expect to get anything from a UN agency, but this happened in that case. But then I explained to the respondent how the UDRP works and what we should do. So let's say that's how we started.
Okay, no, I'm listening. I wanted to say to the folks, the complainant is, they have the mark for AUS, but they were Allied Universal Services. So they have a trademark for a few different terms, and AUS is one of them, and they are on the domain aus.com. And what Igor said about a big employer, from what Igor told me previously, they're like the third largest employer in the US. Unbelievable. Basically, enormous company here. So they really don't like, they didn't like the bad press. And this, Igor, tell us about this respondent, his relationship as a public relations firm, and tell us about the lawsuit prior to the UDRP filing.
Yes, that lawsuit, the respondent filed against the complainant. Well, basically, the respondent was assaulted in one of the shops in LA. And the complainant's guards were supposed to be, on vacation, but they were not there. So he was not protected. And then he was upset, basically. So the shop was supposed to be protected by complainant security guard. Security guard was not there. So that's how the whole thing started. And then again, as I said, that once the respondent, started getting some more information about the complainant, he found out that there are lots of similar stories and other stories. So he created this website. And basically, the website is non-commercial. So there was no banners, nothing there. And it's only for information purposes. There are disclaimers throughout the website. So it's clear that this website is not the complainant's website. And the domain name itself, it's ausfail.com. So it has fail. It has this critical element. So this term that indicates that this is a criticism website. This is a criticism domain name. So our position was pretty solid. Our position is based on the UDRP, on the legitimate interest that we're using. He is using the domain name for a non-commercial purpose, legitimate non-commercial purpose. And again, we also relied on WIPO Overview 3.0 because WIPO Overview 3.0 in principle supports respondents in similar cases.
Jeff, I know if you and David have some questions, please chime in, but I wanted to add, because I want to get to later, these free speech cases. A lot of folks, a lot of domain investors I know think, hey, I have a right to do something similar to this, or at least if it's free speech, is you're not critical of them, but you're a fan site, or you're you're positive, you can still do it in that manner too. But the panelist in this case, George Nahachavansky, who basically took all the information and said, yeah, I don't have to even rule on the bad faith element of this because Igor represented the respondent here and showed that he had legitimate use because he did it in a non-commercial way, and I mean, basically, there's some ways that you can basically, like I say, not get away, but you do have rights if you're using, say your free speech in a non-commercial capacity. But in many cases, we see these domains get transferred away. But in this case, the domain owner got to keep it because he proved that he was doing, legitimate, critical content. So
Yeah, I
Yeah,
was.
this
go ahead.
Oh, I was just going to add the critical distinction here too. In this case, is that there was no showing of any commercial activity. There was no at least showing that there was advertising for money. There were no services on there. I think the complainant, and Igor, correct me if I'm wrong, they tried to argue that you know, um, putting all this material up in social media and maybe even paying for keywords or search engine optimization for the site. They tried to argue that that was commercial activity, and George, I think, came out right and said, no, that's not commercial activity. That's you know, nothing prohibits a non-commercial use of a site to promote their site.
Yeah, thank you, Jeff. And I mean, let me just give you a brief summary of the complainant's argument. So, what the complainant tried to argue, yes, the complainant's arguments, let's say, they try to undermine legitimacy of the respondent's use. So they're basically arguing that, look, this guy, he's a PR professional, he's a public relations professional. He runs his own PR firm in LA. So he knows what he is doing, and he's probably working for some of our competitors. So he's not honest, but they had no proof. And my client was not working for any competitors. He was honest because he was just unhappy, about the complainant. So the complainant didn't provide any proof, any evidence that respondent was working for someone else. Respondent was just telling his opinion was the first thing. Then they try to argue that, look, this respondent, he purchased some backlinks and he tried to use some other, let's say, measures to promote his website. And again, there was no proof of backlinks purchase whatsoever. Again, just allegation without any evidence. And then some of the other arguments were kind of correct, but they were irrelevant for the UDRP purpose, like using email and using social media for promoting this website. They were trying to say, look, their criticism is not legitimate because they sent an email to one of our potential investors, and this kind of disrupts our business. And this guy also has his X account. He has his own YouTube channel, and I think there's maybe some other social media use. But again, this is not relevant exactly to the domain name use and to the legitimate use of the registrant, because as long as his website is non-commercial and he's genuinely using it for non-commercial website, I mean the domain name, then he can use other channels for promoting his website. And this is not exactly relevant for the UDRP outcome. And the third argument there is the complainant try to use, basically they try to say it's defamation and tarnishment. This guy, he goes too far. And look, there is one previous UDRP decision against this respondent in a similar case. And yes, there was one previous UDRP decision against the respondent where the domain name was transferred by WIPO. It was I think 18 years ago, and it was kind of also case related to criticism and free speech, but it had very different set of facts. So we said, look, this previous UDRP decision is irrelevant, and I think the panel didn't even address this previous decision in its findings.
I have some comments. David, do you have any before I go on? David?
Yeah, so I guess the key thing was that, fail sucks. Those are good endings. That the panelists really like to have that ending on the name just to signal that it's a criticism site. So I think that was very useful.
Yes, David, you're right. Absolutely, it's a very important thing for WIPO in particular, because if we look at the WIPO overview, what it says on free speech and criticism, basically WIPO kind of promotes this view that if a domain name contains this sucks, fail, or whatever, like critical element, And if it's used for generally non-commercial website, then it's okay. But if it's an exact match to the trademark, even though it may be non-commercial website, it may be used for criticism, then this may not be okay. And in that case, if it's an exact match, if the domain name is identical to the complainant's mark, maybe it doesn't even matter for WIPO that this domain name is used for non-commercial criticism website. Then oftentimes WIPO panelists transfer these domain names, even though they're used for non-commercial free speech purposes. But in our case, we were kind of we followed WIPO overview approach. It has a critical element. It contains fail, and it's non-commercial. So
what I think is really important here is, okay, so our audience knows they can reach out to Jeff or David when they're running into UDRP cases. I want to say follow Igor. Certainly, you can reach out to him. Very reasonable, very fantastic at representing domain owners. That's if you get a UDRP, but you can also reach out to Igor or like I said, David and Jeff in that matter for preventative measures, because not only they're all very reasonable and you can get a consultation with them, but very reasonable in any cost. Because what Igor has done here is, when you're knowledgeable in domain disputes, Igor addressed, okay, so this gentleman had the domain owner had a dispute in 2008 that he lost, but there's that shouldn't be considered here, and it absolutely wasn't considered here. Very important is, I thought was very important we didn't bring up, was the complainant, after they filed their complaint, and then after the Igor responded for the domain owner, the complainant files some supplemental filing. Igor says to the panel, says to WIPO, you guys know the rules. I mean, you guys set up the rules, and the rules are there's no accepting a supplemental filing unless there's some big change in the case or some facts that are so crucial that were in error or weren't part of the original complaint. Bottom line is, just because the complainant is thinking of more stuff, they decided to file a supplemental filing, and Igor successfully answered that, defended it, and the panelist said, yeah, we're not going to accept this supplemental filing. That's important. So domain lawyers would know to handle it that way. So not only with that past case that his client had lost, but then the supplemental filing by the complainant, but then Igor also addresses all the points that are important when you're in a free speech case. This respondent was not impersonating. Okay, let's be clear on that. And then about the disclaimers at the top of the site, at the bottom of the site. That's why I bring up, if you are doing anything related, something like this to free speech, and you want to be clear and you want to, sort of protect yourself, and you haven't received a UDRP yet, you can reach out to Igor, reach out to David or Jeff, and ask them about, disclaimers. What should they say? And like I said, these guys are very reasonable. Sometimes there is fees, so don't get it, twisted that you can just keep asking lawyers and get free advice from them. But when it comes to preventative, a lot better rates than, when you do actually get a UDRP. But I will say, of all the guys here, certainly point you in the right direction if they're not going to help you themselves, but also they do take in consideration of what's your situation, what is the domain name. You don't want to give it up even if it's an inexpensive name, but you don't want to spend a lot on it. So I just really appreciate Igor joining us and helping this.
Yeah, thank you, Todd.
domain.
May I just briefly comment on the supplemental filing, and just one more thing before we move to the next case. I think on the supplemental filing, just to add that it was kind of surprising for us that they decided to file a supplemental, submission. But what they did, actually, they just tried to re-argue the case and to respond to our response, so kind of rebuttal. And obviously, this is not something that's acceptable in the UDRP, and that's what we said to WIPO. They say, look, we filed an objection. We didn't really argue with the supplemental filing. We just said you cannot accept this because they're basically filing a restatement of the same complaint, but this time they're trying to address some of our arguments, some of the cases, some of the decisions I cited in my response, but it's basically going around the same arguments. So, and WIPO panelist agreed with basically that. He said that no, we're not accepting this supplemental filing. And another thing, in free speech cases, I had another free speech case last year. It was familypolicyfoundation.org, and that last year case was more challenging in a way, because in that case it was an identical domain name, exactly identical. It didn't have any critical element, but we won on the first element. We actually we established that the complainant didn't have trademark rights, but had they established trademark right, it would have been more challenging. So if you want to criticize someone, let's say some organization, some brand, please keep in mind that it's strongly advisable to add some critical element to your domain name.
Thanks, Igor. I wanted to ask you, before we get onto our next case, we were talking earlier about, and you were part of a case, when a complainant files fraudulent documents, basically just submitting stuff that's inaccurate. What was the case that you worked on? What experience do you have with that type of stuff, where a complainant has just filed, fake documents?
Yeah, thank you, Todd. And that was a case early this year. It was a Czech arbitration court case where I was a panelist. I was a single panelist, and it was lemilieu.com case. And I think it's mentioned in the new ICA UDRP digest. And what happened there? The complainant submitted an extract from the USPTO registry. Didn't submit trademark certificate. What they submitted was like an extract from the USPTO with the registration number, with the serial number, but it was fraudulent. So it was a fraudulent document. And what they did, it was an application. It was a trademark application that was not registered, that was filed maybe 10 days before the UDRP complaint was filed, but they kind of made it look like it was filed 2 or 3 months ago, and it was registered, I don't know, 10 whatever days ago. And it was clear to me, because I have some experience with the USPTO, even though I'm not a US lawyer. But then again, there was a response in my case. So the respondent also brought that to my attention. And yeah, it was an RDNH decision. But what was also interesting in that Lemilieu case, in my case, that if you go to the decision now, you'll see that the complainant's name is redacted. So what's happened there, and I was informed by the provider later, the complainant apparently contacted the provider through some European lawyer saying that, look, you have to redact my name from the decision because I never filed this complaint. Someone else filed this complaint, and then I got this RDNH ruling. So I cannot comment on that, but if you go to the decision now, you will see that the complainant's name is redacted. This is an RDNH decision, and what happened after the complainant got an RDNH.
It's great stuff here. You and Jeff are unique in being lawyers on, to help respondents. But like you mentioned in that last case, you're a panelist too. So I can't think of, better types of attorneys to work with than somebody who can, has the perspective as a panelist and knows domain law representing, domain investors. So as I mentioned again, follow Igor. And final question, we're going to get to word date. Was Igor, so anytime now that someone submits any evidence with regards to a trademark, even if it's a Canadian mark or something in the EU, wherever, are you always doing your own research to confirm, verify that it is in fact a real trademark?
I do some of my, yeah, you hear me, yeah, right, yeah, I do some of my research, and at least I try to verify this trademark registration information. But then again, it also depends on the complainant, because oftentimes, when I work for the CAC, and I get most of my UDRP cases as a panelist from the Czech arbitration court, most of these complaints are filed by like big, well-known brands. And in that case, I'm kind of, yes, I look at the trademark registration evidence submitted. Sometimes I check, the registry, the trademark register, but most of the time I'm quite confident that everything is fine here. But yeah, I think you have to be very careful with, with some complaints and some complainants. especially if it's coming from, I don't know, some somewhat unknown firm, somewhat unknown company. And again, you look at the evidence that is submitted, whether it's a trademark registration certificate or if it's an extract from some trademark registry, what it looks like, what numbers, what dates it has. So I would say some degree of due diligence and some kind of verification is advisable, because yes, I cannot exclude that we'll have more of these fraudulent cases in future, and maybe some fraudulent complainants trying to get domain name through the UDRP, because the UDRP is so great, it's cheap and it's fast.
Yeah, these next, well, especially these next two cases, I think are domain names that domain investors would like, especially the third case. We're going to get to these fast. If you have a question or comment for any of the attorneys here, or you have a comment about the front running that we were talking about, raise your hand and we'll bring you up here when we're finished with our cases. This next case I think you're going to find very interesting. I'm going to just give you a few facts and then throw it to David. It's Worday, WORDAY.com. The complainant in this case is Workday Inc., okay, versus the registrant out of the Cayman Islands. We don't have really the registrant's name here, and the registrant of the domain did not reply in this case, which is, not helpful in most cases. You don't reply, you can really get yourself into big trouble, because of the complainant will make all these claims, and of course panelists think, unless you refute it, I'm going to believe the complainant. And in this case, the complainant, Workday Inc., so they offered these enterprise cloud apps for HR and finance, and I thought was, well, I mean, it does make sense. The panelists said that Workday is a fanciful, an arbitrary word in relation to their services, because we all know Workday is something we've all heard, we all talk about, it's a workday. It seems pretty generic, but the panelists in this case said because they use it with these enterprise cloud applications in HR and finance, it is unique, so we'll give it to them. But anyway, they do have standing. They did have a trademark on this. I believe it's since 2006. But so they're going after the domain WORDAY, which, of course, it's just missing one letter from the trademark. But is it, in fact, confusing people? And most importantly, did the domain owner register it with the intent, targeting this particular complainant? David, tell us some facts of the case, and then give us the decision, and then we'll have Jeff and Igor if they want to comment on this. Go ahead, Dave.
Sure. So Workday, or actually just there's only one D in there, so it's Worday, is the domain name.com. And it was registered in 2012, but when you go back to the Wayback Machine, you can see that it was previously registered and it had Backpack Girl on there. Do you remember who that was? Was that Huge Domains, or who was using the Backpack Girl lander?
Jeff, I thought it was NetSol. I thought it was just basic I thought several different companies used it. Jeff, do you remember? I mean,
No, I thought, I think Cedo, I don't know, actually. I'll double check.
he's
All
famous
right.
though.
So in 2009, there's a showing of Backpack Girl resolving in that domain name. It's an Indonesian dictionary word meaning workday, which is, a real word. The other thing is there are a couple of apps out there. One, I think, is a French language app that is a children's game app called Worday. And I don't read French very well, so I couldn't figure out what it was for. But there is a Google Chrome extension that is Worday also, and it serves up every day the word of the day, and you can play a Wordle game with it. So there are legitimate uses for this particular name. They didn't mention there were nuclear marshmallows test in this case. But so in 2019, I see a lander that has a link to GoDaddy after Nick, so you could buy the name on after Nick. But it just looks like it was parked. So right now it's parked at Parking Crew, and that's where it gets interesting. So Yeah, of course, the parking crew was showing infringing ads for Workday that were actually published by Indeed or paid for by Indeed on behalf of Workday or something like that. But there are 10 allegations in there, and number 8 and number 10 are interesting because the complainant says that they made these subdomains, and the subdomains are impersonating the complainant, which is not true because you cannot create subdomains on parking crew last time I checked. And what happens is they set up a wildcard, and currently it actually does have a wildcard set up so that there's no CNAME redirect, there's no subdomains, it's just an asterisk for a wildcard that gets all traffic to the domain name delivered to their ads lander. And you can type in worda.com, and it will resolve to the same lander. So that's how you can verify that. Also, you can use dns.tools to check for subdomains. Now, the complainant wrote, the disputed domain name has been used to register many subdomains, and some of them impersonate complainant. So that's clearly false. And number 10 is the respondent has used many subdomains of the disputed domain names to impersonate the complainant. That's also false. The respondent's use of the disputed domain name to display complainant's trademarks in its click-through advertisements is evidence of bad faith. Well, that's parking crews' fault for allowing those ads for not allowing people to negatively block out certain confusingly similar words that would be trademark infringement. But these statements are inflammatory. So in the bad faith analysis, the panelists didn't really care that this domain name was registered in 2012 and look into how the name was used previously. And actually, for the first couple of years, it wasn't used at all. And then it had forwarding to w.worda.com, and then another subdomain later on. And then a couple of years later, it started resolving on a different parking platform before it ended up on Parking Crew. So that's the history of this name. And yes, it's a transfer. There was no response. But I have an issue with complainants making false and inflammatory statements about a respondent's use of the domain name that really make the panelists overlook certain things. And if a name is like a dictionary word, maybe it's rare, but there are other uses for it, and there are other possible complainants who would have an interest in this name, why should it be transferred? That's my question. What do you think, Jeff?
Yeah, unfortunately, it's one of those other cases where the parking company, and whether that was selected by the registrant or the registrar, most likely the registrar, I think, I know the Team Internet Group is responsible as the corporate umbrella, but, it just shows you again how these damn parking pages are getting their registrants into trouble and becoming the overriding factor, right? There's no evidence of real targeting except for that, you know, um, parking links, which if you go there still right now, you will see links to Workday. It's unfortunate, but the registrars and parking companies, because they're not affected by this, they don't care. And they're not going to change it because the revenue they get from doing it, it exceeds any kind of risk. And, you lose one or two customers or 10 or 15. Who cares when you're making all this money? But again, it's unfortunate that parking companies are getting their customers into trouble.
What's frustrating to me is panelists will say parking is not a bona fide use, but yet parking was also, it was set up way back in the day because people were going to websites, nothing was there, till finally parking was there, and it makes sense, and it really is a use of names. I know people don't like it, but Igor, when you get a case, you're a panelist, you automatically, I mean, not automatically, but parking in this case was ruled not a bona fide use of the domain name, how do you determine whether it's bona fide or not? If they answer, then it's bona fide. If they've selected, if they've reviewed, say the domain owners reviewed many parking companies and then decided on one, and they've you know aggressively or say offensively decided on what links to have on there because they want to make sure they're not, infringing on a mark and they're trying to maximize the money they make. I mean, when is parking bona fide?
Some panelists would say it's never bona fide, unfortunately. But there's no easy way to answer it. It's bona fide when you have a good attorney that represents you and explains the situation, um, as to lack of control over that, and that's up there strictly by the registrar, and you're not getting any money from it. But yeah, I mean, there used to be cases where parking was considered a bona fide use, but not anymore.
Not getting any
I
money
think
from it.
that
That's just silly. Go ahead, Igor.
I think it's a really tricky question. First of all, response really matters in such cases, and in that case in particular. Well, second, unfortunately, there is not much knowledge among the panelists about the parking, how parking works and what it means actually. And most of the UDRP panelists are just lawyers, and I mean, including myself. But I'm trying to get some extra education about parking and some other stuff. So I mean, that's one of the reasons why I listen to your show. Even if I cannot join you live, so then I listen to the replay. And again, it's a combination of factors. For me, it depends on how strong the complainant's mark is, what evidence is submitted. So parking per se is not like bad faith, but some panelists would say that yes, parking, use it for use of the domain name for like parking page is not bona fide use, and it may indicate bad faith. And I think yes, there is general lack of knowledge.
And to agree completely, and would say that this is especially the case if there's no response,
Yeah.
then you've pretty much lost.
Yes, yes, yeah, that's true. There's no, and that word day case is a good example. I think it's potential. It could have been a defensible case potentially. And again, we're not privy to the submissions, to the complainants' filings, and to the exhibits and annexes. They were submitted. It's quite possible, as David was saying, that maybe there were some allegations without any proof. Again, I see sometimes, and again, I'm not saying that this was the case, but sometimes, when I represent respondents, and I represented a few respondents already, and I think in every single case where I represented respondents, complainants made some allegations without any backup proof. So it was just an allegation that the respondent was doing something, the respondent wasn't doing this, but this allegation wasn't the complaint. And had no response been filed, so I don't know how the panel would have decided the case. So response definitely matters, and allegations I think are quite common.
Well, the more I think about it, the more it just doesn't make sense that parking is not a bona fide use. Parking companies, and we're going to be talking about parking at NamesCon a lot. Been talking with the attorneys that are going to be on the set panels with me, and yeah, no holds barred. We're going to talk about the problems these parking companies are causing, what the parking company should do, and we're talking about Parking Crew, Park Logic, Above, the one that Rick Latona runs, Giant Panda or Panda Express or whatever it is. I don't know. They should be having, when they go to these events, they should be talking with the attorneys and panelists. They should be talking to domain investors and saying this is a legitimate use of your name. Of course, basically with the domain, I mean that's all parking is you take your domain name, you send it to their landers or use their servers, and you're doing it to get the little bit of change. And a lot of domainers say parking's dead, but then I want to hear from these parking companies who will tell you, that's their whole business. Apparently parking's not dead, and it is a bona fide use of your domain name.
Yeah.
So yeah, go ahead.
Yeah, no, I just wanted to say that's a very important point, Todd. I think yes, you have to talk to other people and other businesses. And as you're saying that, parking companies should explain what they're doing. And it's good if, parking companies talk to other stakeholders and maybe to UDRP panelists and, other lawyers. And when it comes to UDRP panelists, I think one of our common problem, and when I say our, I mean UDRP panelists in general, our community, that oftentimes we just talk to each other. So most of us are trademark and IP lawyers, so we just talk to other IP lawyers, to other trademark lawyers, and we don't really listen to other people in the industry, like domain name investors, parking companies, registrars, and let's say some other stakeholders and participants. So I think it's important to have this conversation.
Yeah, the registrars, of course, I don't consider them parking companies, but they have these parking landers. So registrars and all the parking companies, they should have went to the big WIPO 25-year thing this past year and said, "Hi, we've been doing this forever. You guys consider this no bona fide use." But then also they should say, and of course they'd never do this, but we want to indemnify the domain investor. Jeff's brought it up forever with GoDaddy. They got a disclaimer on their parking page that says GoDaddy didn't select these links. These are done by our parking partner, but yet it doesn't say the domain owner is not responsible for this. It should be we're not responsible. The domain owner's not responsible. Basically, they want to, the parking companies and the registrars make money a lot off of parking, enough to where, so that what they should be doing is spending some of that money going into these events with the panelists and the lawyers and basically lobbying, saying, you guys, when you get any cases with PPC pages, you should be knowing it's a legitimate use of the domain name, period. It's a legitimate use. But of course, when someone registers a name and it goes to a default parking page, they want to, there should either should be allowed or not be allowed at all. So I just don't, the more I think about it, it's frustrating. This next case you guys are going to want to listen to because it's a great 4-letter domain, omis.com. Okay, that last case, that was a transfer if you didn't catch on. So this Hector Manoff was the panelist, ruled that, Worday, WORDAY.com, was the registrant knew. He should have known of that complainant. Matter of fact, the panelist said, he did know of the complainant, and was parking wasn't a bona fide use of it, and so on. And just they said they read the name with the complainant in mind, which there's no proof of that at all. But it was a transfer, so it shows you do reach out to a domain name lawyer, or at least answer yourself. Answer yourself and just say, hey, I didn't even know about them. Maybe it'll stick with the panelist. Okay, this last case, omis.com. It's an American premium, and it's pronounceable, OMIS. Okay, this company, OMIS Group, OMIS, out of Italy, filed this complaint against Media World. It was, I think, Media World Advertising International, something, but they're out of the UAE. Okay, they filed this case, and the complainant, but their big company makes cranes and hoists and lifting equipment since 1967, but a big company, and they use OMIS as an acronym. Okay, so their company, I don't even have it. It was long Italian, but OMIS was the acronym. And in this case, the disputed domain name, omis.com, was not resolving to a website. Now, you look at the Wayback Machine and you see it had changed. It appeared to have changed hands several times, because from prior to it was like 2019, I believe, to 2024, it had a catering company, an Austrian catering company called OMI with an S, OMI's, but before that it was something else. So we can see that other companies had used this type of domain name. But anyway, so the catering company, I bring it up because this complainant had reached out to the catering company and was like wanting to buy it. And they reached out to him in May and June of 2022, but the catering company didn't even or declined an offer, and then they ended up going bankrupt. The company did, this OMI's catering company. So what happened was they went bankrupt. The domain owner that owns it now bought the domain name. Hopefully got a good price. I probably should check named bio, but it's probably not there. But he bought the name, and then the complainant was like, damn, we wish we would have got in there at that time. We didn't know. So they offered the respondent something for the domain name. I didn't catch an amount. Maybe they just inquired about it, but the respondent said, yeah, if you want to, it was, I think, a broker replied, but said, yeah, if you want the name, minimum offer 120,000. So that's when the complainant filed the UDRP. In this case, the respondent didn't respond. So keep that in mind. The respondent didn't respond. I find this very interesting before I give you the decision and some other facts of the case. So the domain omis.com, the complainant, you know, reached out to this domain owner who acquired the name in 2024, inquired about buying it. The domain owner responded, or we think they responded. Maybe it was a broker. We don't know specifically who responded with, you need to make a minimum 120K offer. And then that's all we know before the complaint was filed. So, and there was no response. So we don't know, was it targeting? Was it not targeting? Jeff, go ahead and tell us your thoughts on this case. And if you want to give the answer, go ahead, and then we'll go to David.
I thought David would want to go first.
David, omis.com, 4-letter.
Yeah, so the decision mentions this city name, Omis, in Croatia. It's actually pronounced Omiš. And I've been there. It's a beautiful place. I didn't go we call it when you riplining, when you go from the canyon one side to the other. My girlfriend wouldn't let me. But
Zip.
yeah, it's a beautiful place to go. It's right on the Dalmatian coastline. There's a nice beach there. And I just spent time just driving through, stuck in traffic. She said, let's keep on going. So anyway, beautiful place. I want to go back there one day. It should have been a directory site for that city. That's the best use case for this particular domain name. And this complainant already owns 15 Omis dot whatever domain names, and their main site is on the .net, and it just goes to show you that the .net is not good enough for them. They want the .com, and so they'll do anything to, hey, file UDRP, let's try to steal it, but they don't want to pay $120,000 for it. Well, why not? It's a 4-letter pronounceable geographic place. It's worth it, definitely.
Yeah, the thing I really like about this case is the research that the panelists did. Using lines like it's not. He doesn't say this exactly, but essentially, 4-letter names. $120,000 is not an unreasonable price, which I thought was actually what he says is that. I want to find exactly. Noting that many reported sales price of 4letter.com domains in 2024 exceed $100,000. So basically, what they're saying is, look, the fact that it's a high price, that doesn't show targeting at all. You haven't shown, you, the complainant, haven't shown targeting. You haven't shown that they would have known about you. You haven't basically shown anything other than the fact that you have a trademark, so you satisfied the first element. And I think they established a second element too, which is that, again, the respondent didn't respond. So it's kind of hard for a respondent to succeed on the second element when it doesn't respond. But thank goodness that Scott Blackmer did some research on the bad faith and I think came out with the appropriate finding, which is, look, the price alone you can't look at. You still have to show that it was acquired primarily for the purpose of selling it to the trademark owner or a competitor. And to make that inference here, there's no evidence that would suggest that kind of targeting. So that's, I think, for me, what I really liked about the case.
Yeah, Scott Blackmer, he's what a domain owner would want. You didn't, in this case, didn't respond, but yet Scott did some research and felt like 120 is not too much, and you didn't prove the targeting. Igor, if you're a panelist in this case and there's no response, would you, I mean, 120,000, I mean, how much research do you do in the case like that? I mean, some panelists I know, they're only going to research anything related to the evidence. They're not going to go further than that. So is this, do you think, a lucky decision for the domain owner, or would you have ruled the same? And how much research would you have done?
It pretty much depends on a panelist, because all panelists are different. Someone would do the same, and someone probably wouldn't do any research at all. Just look at the submissions, the complainant submissions in that case, because there's no response. But here again, here is an important thing, that it's a four-letter.com domain name. So myself, I would be very careful with what the complainant is saying. If it's a four-letter.com domain name, if the complainant doesn't, itself has a .com, have a .com domain name. So here the thing, that why the complainant doesn't have this .com domain name, and what the complainant's trademark is it like a famous trademark that everybody should be aware of, or if it's some maybe local Italian, in that case, trademark that may be known in Italy, maybe in some neighboring countries, but maybe it's not known in the Emirates. I think the respondent was from the Emirates. So I think I would have reached the same conclusion as Scott Blackmer, because in cases like that, when there is like 3, 4, 5-letter domain name that can be attractive to number of users, if the complainant's mark is not very strong, I would do some research to verify whether there are any other users of the same name, maybe any other trademarks, just to see whether there was targeting. And in that case, I think this is the correct outcome, that there was no proof of bad faith, and I agree with that decision. But again, as I say, we're all different, and panelists are also different.
Well, I think domain investors should listen. I mean, I love it because you guys are saying, yeah, 3, 4, like you mentioned, 5-letter short domain names. You guys aren't domain investors. You and Jeff really aren't domain investors, and David is some, but he, I know, feels the same, and that is, when it comes to short domain names, they're attractive for many reasons, and it's not that you're giving them the benefit of the doubt, but maybe a little bit, meaning, yes, there's likely several companies that would find these types of names attractive. Why? Because they're short. They're short, and they can be an acronym. So when you're investing in short names, I will say it's nice to hear that some attorneys and some panelists feel that, hold on, there's likely numerous people that would be interested in this because of how short it is. And I think that's important. There's a lot of folks who, it's not maybe a monetary value of owning short names, but it's nice to know people outside of domain investors find them to be, different. Maybe they think, whether it's truth or not, they think may be attractive to end users or to several parties, not just one party. So I like it. I like that. And this was, great letters, OMIS, but I wouldn't have known it's a vacation spot. I wouldn't have known it was some catering place. I wouldn't have known anything other than there's a place right near me, Somas, SOMIS. I realize, but I wouldn't have known other than it's a 4-letter with great letters, and I could, imagine a lot of different companies would like to have this name, whether it's OMI and they have the name OMIs, or the complainant in this case happened to use it at a long acronym and decided OMIS was something that they wanted, and they filed a complaint. Hey, I appreciate everybody being here. I wanted to say on this Thursday, 10 a.m. Pacific, 1 p.m. Eastern, Josh Reason and I do a room. You guys, most of you know it, DNX show. It's here on X. We also stream that on YouTube, but we have a lot of topics, a lot of stuff going on in the domain investing space. Bottom line is, I heard that Richard, we say Richard like we know him. I never met the guy. Everybody in the business knows him that's been around. I know Jen Sale over at Ever, and she calls him Ricky. Anyway, Richard Kirkendall, who runs Namecheap and Spaceship, posted $2 million Bitcoin transaction, basically a $2 million sale on Spaceship, the biggest sale in their seller hub so far, and it was somebody paid with Bitcoin $2 million. Interesting. Didn't mention the domain name, but yeah, there's a lot going on in domain investing, and we're going to talk with Josh more about He's been registering thousands and thousands of names, hand registering thousands of names. So we have a lot of domain investing topics. It's an open discussion. So bring your questions on Thursday and join the stage. And we're just going to talk domain investing for a couple of hours. Until then, I hope you have a great rest of your day wherever you're at. Thanks, Igor, for being here. Really appreciate it. And always thank you to Jeff and David, my co-hosts. We'll see you next Tuesday on the Domain Name Law Show. Take care.
Thank you all. Thank you, guys.